All right. Good morning, everyone. Welcome to the July 22, 2025 meeting of the Oldham County Planning and Zoning Commission. I am Greg King. Before we get underway, if everyone will please join me in the pledge. Thank you, everyone. And also at this time, take out the electronics, set them to mute or silent, whatever it takes for the duration of the hearing. First order of business will be approval of the minutes this is from May, is that right? Yeah, this is from May. May 27, 2025 minutes. Can I go ahead and get a motion on the floor? Mr. Marsh, is that you?
Yes, move to approve the minutes.
Do I have a second? Ms. Jones, is that you? Okay. We got any edits, corrections, updates? Ms. Jones?
Yes, we have a few. Okay, on page 3 of 16, it's number 2 toward the bottom. And it should be, the last part of that sentence should be, and is now being converted into a daycare instead of not.
Okay.
And page 7, Ms. Kraus was left out of the yes votes.
All right.
And then on page 9 of 16, it's the 8th bullet point. It says not meeting the minimum lot width, and that is, I think, just should be taken out. Mm-hmm. Okay, and then on page 12, once on page 12 and 3 times on page 13, Ms. Krause's name is spelled wrong. There's no E.
All right.
Then on page 14, and I'm not sure if this is just condensed, but let's see, it's under number 1, the 3rd bullet point, where it says purpose of moratorium. I think it would read better if it said is to allow staff time to create ordinances. Not sure if that was just condensed, leaving out the is, or if the is should go in there.
All right.
Okay, that's all I have.
That's it?
That's it.
Anyone else? All right.
Oh, sorry.
Mr. Fisher, please.
Sorry, I forgot I got an email from Jim Silliman that told me about one. So Mr. Silliman said on page 8, at the bottom there, it says County Engineer Silliman specified turn lanes. He said that would be evaluated should be added to the end of that statement, since he was saying what he expected from them. So Engineer Silliman specified turn lanes would be evaluated.
All right. Anyone else? Good to the cause. All right, all those in favor of approving the minutes as updated and corrected, please signify by saying aye. Aye. And those opposed, like sign. Minutes are approved. All right. Move into the first and only docket item. Ms. Edgar, you ready? Oh, let's go ahead and swear staff in, please.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Yeah.
Docket PZ-25-018. An application has been filed by Jennifer Turpin requesting a waiver of Oldham County Subdivision Regulation Section 5.7E, joint access, fifth parcel on access easement located at 1900 Liberty Lane, Goshen. The property is 10.035 acres in AG1.
Thank you, Ms. Edgar. And we ready for staff's presentation?
Good morning, Commission. Sandy Rick Road and Planner 1. This is, as stated, waiver of regulation access easement for 1900 Liberty Lane, Goshen. An application has been filed by Jennifer Turpin requesting a waiver of Oldham County Subdivision Regulations, Section 5.7E, joint access, 5th parcel, on access easement located at 1900 Liberty Lane, Goshen. The property is 10.35 acres in AG1 Agriculture District. Again, we just went over this information. AG1 agriculture land use is the land use, 10.35 acres. On the site history, October 5th, 2007, there was a minor plat administrative review and approval to split and sell 1.169 acres. I'll have that plat later on in the presentation. That is the only one that I could find of all of these parcels. It was posted to the website on June 25th. Adjoining property owners' notice were mailed on June 26th, and it appeared in the Oldham Era on July 3rd. Here is an aerial of the property in question and the zoning, as mentioned. So the applicant is proposing a minor plat that will create a 1-acre tract from the 10.35 acres of the total parcel. The existing tract includes the existing primary residence and attached garage. The proposed tract does not currently have any structures. In creating the new lot, the access easement would now have 5 parcels, which takes access from it, thus requiring the waiver. The applicant is requesting a waiver of Oldham County Subdivision Regulation 5.7E for the approval of a 5th parcel on access easement. The applicant will prepare a minor plat and shared road maintenance agreement between all parties involved. And here are the regulations for requiring no more than 3 parcels take access from any single road, private road. So here you see, these are the this is where you would come in, and this is Liberty Lane. It's hard to see with the red over it, but you'll see it on the next slide better. And these are the existing parcels that are using the access on Liberty Lane. So it's already 4 parcels when you're only allowed to have 3. So here's a better view of where you can see the access is. You can't see the existing 4th parcel, but it uses this road back here because it's much further down than there. But I wanted to give you an overview of what they're using now. And here's that one minor plat that I could find. Again, the rest were created a while before 2007 at a minimum. In summary, the applicant is requesting a waiver of Oldham County Subdivision Regulations Section 5.7E for the approval of a 5th parcel on an access easement. Potential conditions of approval. The waiver shall only apply to the plan reviewed at the July 22nd, 2025 Oldham County Planning Commission public hearing. Prior to minor plat application, applicant must go to the Board of Adjustments for road frontage variance. We added this yesterday after reviewing the case again, so this was not in your staff report. A minor plat application and survey must be submitted to staff for review and approval prior to issuance of any building permits. And finally, a shared road maintenance agreement shall be prepared, agreed upon by all parties affected, and recorded with the minor plat. And that's all I have. Any questions?
Yeah. Anyone else from staff? Mr. Silliman?
I really don't have any more to add other than I was here in case you had any questions about public road maintenance or right-of-way, because Liberty Lane is a little confusing in that where it terminates, let's see. Where it terminates at this point, depending on what plats you look at in the records, it may indicate that it's right-of-way. Most of them indicate that it's not. And then this is definitely, on most that I've looked at, is indicated as a private use. So our county maintenance ends at this point. This is not a county-maintained road. But again, I just wanted to be here in case you had any questions regarding our maintenance responsibilities or right-of-way.
Thank you, Mr. Silliman. All right, commissioners, or Mr. Fisher.
I was just going to ask Sandy if she can show where the proposed 1 acre tract will be on one of those slides, or if somebody has a plat already drawn up that's going to show the commissioners where that will be.
I do not I've not received a plat. The plat has not been submitted yet, but it would be, the applicant, correct me if I'm wrong, but I believe it's going to be like right in this area up here.
All right. If I can get somebody to come to the podium, please. And I need to swear you before we get any testimony. So name and address for the record, please.
Irv Turpin, 1900 Liberty Lane, Goshen, Kentucky, 40026.
Thank you.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right. So what were you saying?
I don't know. Well, oh, yeah, it'll be looking north, it'll be to the right of the drive to our house. It'll be the quickest 1 acre right there. Right, the house will be right where that arrow is. And
We're gonna get through the rest of the details when we get into your presentation, your applicant's presentation.
okay,
Okay? I hope you're ready.
I guess.
All right, so that's it for the moment.
All right.
Going back to questions from the commission now for staff. Questions of staff. You can be seated. Thanks. Yeah, please.
Sandy, can you highlight on the screen for us the existing, I guess because they're asking for a waiver for the 5th. Where are 4? Show me 4 on
Okay,
that.
let me go back. It's hard to get it all in one frame because one of them is pretty far back. So if you see here, I'm going to go back and forth between 2 sites. Okay, so if you see here, you're going to see 3 of them. Okay, that's this top area right here is going to be the 3 of them. And then this is the 4th back here. All you can see when you're looking at this aerial is the driveway that goes back to it. See, because this one's back here. So that new parcel is going to be right about here.
This one accesses from that one.
Okay, so sorry. So this is right about where the new parcel is going to be, right in here. Sorry, this mouse gets sticky. So 1, 2, 3, 4, and then there'll be the 5th access.
So I guess just for clarification for me, that roundabout is considered part of this easement. Why wouldn't the other side of private lane be considered easement too? I mean, it's all private road for that whole area. Why is the roundabout?
Jim, you want to?
I guess I'm just confused on the roundabout. Why it meets,
Well, the roundabout's really just a driveway on private property.
Right.
I think it's independent of this discussion. What we're looking at is
so why
this road in this direction.
So then technically we're looking at 3 existing, not 5. If we're looking at private road, I'm just trying for clarification. I mean, if the roundabout is on private property, not sure. I mean, I'm just confused on it. I mean,
It's still taking access off of that easement, though.
then why don't we count all the roads that go to the other side of that roundabout?
It's
On
a
the other
circular
side?
drive on
Well,
someone
it's a
else's
separate
private
drive, but
property.
there's about 9 tracks on that side. I mean, but that's not in question here. So there's 2 separate access easements that come in off of there, and so we're dealing with the one as you come in Liberty Lane that turns to the left. So that driveway technically comes in from both of them, but for these purposes, takes access off of that. You've got the other two tracks. Now, the question would be is, if the one in the back, if it takes access off of that driveway, if that's true, I think they may have some testimony here in a second that may differ to that. If that's the case, then we're simply looking at 3 and we're asking for a 4th. Either way, they've got to ask for a waiver, whether it's the 4th or the 5th.
Right.
So,
I just didn't know if it comes down to it, somebody else subdivides or divides into the piece of property.
but I think the applicant may have some testimony that might answer some of these questions as well.
Question, is this the first time we've ever made a decision without having a audit survey? My recollection, I don't remember.
I mean, that's not something that they have to provide. We usually encourage them to do that, but I mean, once again, they're going to have to get a road frontage variance on this. So at some point, I mean, when they come in and apply for a minor plat is the time they essentially have to have that survey done. And if it doesn't meet, then they've got to come back. So at the point when final approval takes place is when they truly have to have the plat survey. But most of the time, yes, they do have them at this point.
All right, we're good? All right, who else? Mr. Finney, I see you scratching your head. No questions yet? All right. That it, Commissioners? All right, we'll move into presentation from the applicant.
I can explain it. The applicant is my daughter, Jennifer, but I can explain everything you're all talking about, I think, better than she can,
Counsel?
if that's okay.
Okay.
He's
Okay,
already
if you
been
go-
sworn, so, and he's testifying on behalf of the applicant.
The red lines. Yeah, that one.
Here, let me make it bigger too.
Okay, we own the 13 acres where the roundabout is. We owned that initially, and then we sold off the 3, and the roundabout goes with that house, the original house, and then we built to the right of that. And at that time, when we came to planning and zoning, they told it, the lawyer at the time came in for planning and zoning and said, my plat that we purchased the property initially showed that Liberty Lane went past our house and down and ended down towards the next parcel. And she stopped, for whatever reason, I can't remember why, but they determined at that time that Liberty Lane would stop in front of the 13 acres and it wouldn't be maintained to the right back when we applied for our permit to build. So that became a private road at that point. Since then, all the property around us was Boone Gardner Nursery, and they auctioned those properties off in different parcels. So if you go past our new house and down to the next parcel, which is owned by Ben Mackey now, initially it was purchased by him and his wife, Dace Brown Mackey, and they bought I can't see the number, but the biggest parcel. Well, then this one in the back of our property, the one that's in question, that was sold to another buyer, and then they chose not to build and sold off to the Mackeys. So the one that you're all saying, this road on the left comes down and becomes that parcel, that is attached to Mackey's property. That's not, that road goes back and dead ends into the main house on the Boone Gardner Nursery. It doesn't come back to that property.
Sandy, can you show him how to use the mouse?
Yeah.
Sorry.
That's a good idea. I should have done that. I got it. Thank you. So this one right here, that is part of this now. So that parcel actually is part of that whole 200 acres or whatever the number is.
Can I, can I interject there?
Messed it up.
Those parcels have common ownership. Is
Yes, sir.
that- But they are separate platted pieces of property for what it's worth, guys, okay?
So this road right here, like Liberty Lane ends right here. Well, this is a private road back to a different property, not to the one behind our property. It seems that's what they're saying, that this road goes and attaches to, how do you go back to that? Sorry. I tapped it and messed it up, but the red line was. Yeah, thank you. So this road here, when you come back, that's 1806, and it dead ends into the old homestead of Boone Gardner. To access this, when they purchased it, that would have been coming back this road down the side of our property, which is an old road, and then it came into this parcel. Well, now this parcel is part of this parcel. And the access would be down this old road, which is just a gravel, old dirt road. No access, well, there is an access through the woods, but like I say, they're separate. That's separate from this.
Can I just make one thing clear, is that those parcels are still separate, they're just now owned by the same person.
Thank you.
All right, anything else?
No, sir.
Counsel? Do we have testimony that we can decision on here?
Well, Ms. Turpin, why don't you come up here and explain, you filed this application and probably need to give us a little bit of background about why you all are doing this, what the purpose is, what's going to ultimately happen so they can understand.
All right, so name and address for the record, please,
Jennifer Turpin, 9101 Judge Carden Boulevard, Crestwood.
and raise your right hand, please.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
And before you get started here, okay? There's just a point of order in how this commission makes its decisions in this space. It's governed by state law. KRS 100 governs. So in order to make a motion that this application is going to be suitable and appropriate for this commission's support, they're going to have to make a couple of arguments for the motion making. The arguments go like, hey, strict compliance with the regulations would create an undue hardship. We haven't heard anything yet about what that might entail, if that's one of the reasons that you want to think about arguing for an approval. The other says that design innovations in the case basically won't circumvent the regulations. We haven't heard anything about this yet, and we are not able to make decisions on what we've heard thus far. So this is what the applicant brings to the hearing, is an argument for why this commission should make that type of decision. Okay? That's what we're trying to get to here. All right? You're up.
So you want me to explain why that I want to build or get the approval?
So your objective today is to get an approval.
Yes.
If your objective today is to get an approval, this commission has to make a motion in your support. And again, strict focus in terms of what type of decision we're able to make. If you can argue that strict compliance with regulations would create a hardship, we can't come up with that reason on our own. You have to provide this. This is the way this hearing works, is that you're making the argument. If it's a plausible argument, then the members of this commission pick it up and say, that's an argument for why we should do this, okay? Or you can say that there are design innovations which achieve the basic intent of the regulations that don't circumvent the regulations. Again, this is an argument that this commission can make if you provide the testimony. We can't create it on our own. We can't just concoct it out of thin air. That's yours to bring to the table, okay?
Chairman,
Yeah.
if the chairman would entertain this, I would like to make a 5-minute recess for her to convene and speak to her parents about justification. You don't mind?
Fair game.
We have a second?
All right. Do we have a second on this? Go with voice vote. All in favor, please signify by saying aye. And opposed, like sign. All right, you guys have a few minutes here to circle the wagons and come up with your argument, okay? I have that as a typical expectation, whether or not that's procedurally and structurally so.
Director?
So they're all way before.
I mean, isn't that what, in their pre-app application, that's what, they're supposed to show them maybe this page and be like, okay, can you argue this with the board? I mean, I'm just secretary.
No, it's a great question. I'm stumped. I'm stumped.
Listen, I'm like, I'm just a secretary. But I've been here for about 3 years, so I think I know.
You know, you're showing tremendous aptitude.
I mean,
So
I
we
mean,
really,
they should show, I mean, really?
we don't even have a, we
Show-
don't even have a
show this-
plat to consider here
Right.
to give it a chance to succeed.
Yeah, show this page to me and be like, okay, you need to argue this. Ryan? Isn't that, wouldn't that be what you all do in staff meetings?
What?
Is to tell these
Talk to
people?
them? I wasn't here for I don't know when it even happened. Jim was here, that's why he's up here. I don't know if it happened when I was gone or.
No, like when they sit down, don't they sit down and have Oh, it has been me
These
for the
up here
last
too,
couple of
right?
meetings.
These up here keep going in and out too. Right, it's either we're haunted or. Yeah. Oh, there you go, right?
Do you think Rob will come up and tell us what we've done wrong when we're done? Oh. Can you put a guitar in your hand and sorry.
All right, back in session. All right, applicant? Unless anyone else has something for input here.
Well, Mr. Chairman, I took an opportunity to speak with the Turpins in the hallway. I think they now understand maybe the confusion about where they are. Mr. Turpin explained something to me in the hallway that I think he would like to get up and explain. And perhaps after that, the county engineer might have a comment he would like to make about what Mr. Turpin says. So that might get us where we need to be, might not, but we'll give it a try.
All right, let's give it a try. Mr. Turpin.
Yes, sir. Okay. I have the original plat that I didn't bring it with me, but I can bring it the next time if we have to come back, that shows that Liberty Lane, I tried to explain that earlier, but Liberty Lane used to come here, and then on our original plat, it went to the east and then down to the south of our property with telephone poles that actually run down, they still are there, that run down the old Liberty Lane to where it dead ended towards the south of the property. Those telephone poles. Okay, yeah, there you go. Thank you. So Liberty Lane ran this direction back to here, and it dead ended right here where this drive splits off to the old farm of Boone Gardner. Well, then there's telephone poles that run back the gravel road to that property that was in question about being another parcel. So the engineer is what I meant. I said attorney last time, but the county engineer at the time, when we applied to build this house, the existing house we're in, and sold off the old house with 3 acres, the engineer determined at that time that Liberty Lane would stop maintaining at this point, even though they gave us access to build. They still cut off Liberty Lane at this point here. So, that being said, the only other access back here would be to this farm, and nobody resides on that property. It's for business purposes. So, our argument is, if they approved our house, even though they cut Liberty Lane off, one more house or one more parcel, this 1 acre here, we think that would be okay to approve because they approved this one. And then if you go back this direction, which that's not Liberty Lane, but it still shows as Liberty Lane. It's a gravel road that goes back to 3 different houses back that road that have been approved over the years that we've lived here. So we're just asking the waiver to be approved for the same reason that the houses along this lane were approved to be built. And there's really nobody that we would be infringing on with this waiver, because this back here is not residential, it's a farm, so it's a cabin with barns, and this shouldn't affect anybody, or I would think they would be here if they did receive the letter that I'm aware of, so you would think they would be here to go against it.
Mr. Chairman, I may be out of order.
I'm sorry?
I may be out of order, but Mr. Turpin explained something, and he's struggling a little bit right now to articulate it for you all in the hallway. Okay, so Mr. Turpin, you said you have the original plat when you purchased the 13 acres.
Correct.
Right? The whole property.
Correct.
And it showed on there Liberty Lane extended to, I would assume that is basically the east. So Liberty Lane comes in, for the purpose of this picture, from the north and dead ends at your property as shown here, correct?
Correct.
But the way you explained it to me in the hallway, the plat you have actually shows Liberty Lane extending to the east. To the east here.
Yes, it goes right
towards that piece of property and dead ending at that point.
Correct.
And when you came and got I don't know how big it is, but the roundabout property got cut off, and then you came to get your house approved on the 10 acres that you've got.
Correct.
The county engineer at the time said that what the plat that you had showed, she had changed her opinion, or not changed her opinion, but her opinion was it dead-ended at the roundabout.
I don't know that she made that opinion. She just determined that it would at that point.
And you had understood, though, up to that point that Liberty Lane went in front of the 10 acres that you were proposing to build on over to this house that is, I don't remember who owns it, but owns this piece of property to the far right.
Correct.
And that was what your understanding at the time you purchased the property. And you've now been told something different.
My plat says Liberty Lane. My plat shows Liberty Lane with the survey pins going right down this road, around the curve, and coming back. And I'm not sure that it dead ended right there, but it does go all the way to the east and then starts south down this old, like I say, it could have been 100 years ago that was a through road. I don't know. But it goes all the way back, and now it dead ends into a farm field, a cornfield.
So if your plat was right, you have frontage on the road, and the acre that you're trying to give your daughter would also have frontage on the road.
Correct.
However, based upon this, you're trying to get an additional access point to this piece of property from what is shown on here is the end of Liberty Lane.
Correct.
Which is a change in circumstances from what you understood at the time you bought it.
Exactly.
Have I articulated what you told me in the hallway
a lot
correctly?
better than I do. Yes, sir.
All right. Okay, thank you, sir.
But I do have that plat at home, and I should have brought it with me. I just wasn't thinking at 6 in the morning. But like I say, it shows the pins, the markings from the survey before we actually bought the property. It was owned by Hoops. The last name was Hoops.
Okay, anything else?
No, sir.
All right, anything else from you? All right. All right, you can have a seat. Anyone else here wishing to speak in favor of this application? Anyone wishing to speak in opposition to this application? All right, commissioners, you're up.
Mr.
Questions?
Chairman.
Go ahead, Mr. Marsh.
I understand what we're doing now. I still don't believe I've heard why we are doing this. Can we possibly get applicant to explain why this request is being submitted? I believe it's part of our packet, but I haven't heard it in testimony.
So I just,
Let's get you close to the mic, thanks.
my parents are getting upward in age. and and I just wanted to be closer to them. I've never had a place of my own, and I'm just ready to build. I'm at the point in my life where I want to do that, and I want to be closer to them. So as they grow older, I can be there to support them. And I just want to have a house of my own that I've never been able to have before.
All right, thank you.
Excellent, thank you.
Mr. Marsh, you good?
Thank you.
All right. Mr. Douglas?
Mr. Sullivan, can I ask you a couple questions? We keep hearing about this original plat. Do you know anything about that?
When they visited our office, he had an older, large plat. I don't, do you recall what date that was? No. Okay. And like I said earlier, depending on the references I look at, whether it's the plat that Sandy referenced that does indicate, and if, Larry, can I use the overhead? Bear with me, I just brought paper copies. So.
While you're considering that until everybody looks at it, the plat you're looking at, generally, when someone puts on this 30-foot roadway easement, identifies Liberty Lane variable right-of-way, 30-foot, wouldn't that be considered as, I'm not taking
As
your
right-of-way?
thunder. Yeah.
No, not necessarily, because that 30-foot roadway easement could be an access easement amongst private property owners. And that's the way it does appear to be reflected. And that's for the portion, again, to the west of where Liberty Lane maintenance ends. Again, Liberty Lane extends to the north up to 42. Our county maintenance ends about at this point. To the west, there's this portion with the 30-foot roadway easement. To the east is the portion where, again, depending on what source you reference, it might indicate that it's right-of-way, like this one. There's another survey from, this was done by, I believe, David Garber in 1996. And similarly, it shows, and I've highlighted in pink where we maintain Liberty Lane. It does show to the east a little segment of right-of-way, but I think the most concise survey that I've found that's recorded is this one. I'll lay in front and get the north arrow oriented correctly. And this one, what this one shows is right-of-way of Liberty Lane going north to 42. And then this is the segment we're talking about, where it goes to the east. There's a small portion here. It's about 1/10 of an acre that when this property was subdivided, this portion was dedicated to public right-of-way. So what that indicates to me, and it's dedicated to the center line. So what that indicates to me is that when that property was subdivided, planning and zoning requested that road frontage be dedicated for future use if we ever wanted to dedicate that road. And that's what happens occasionally with minor plat subdivisions. We have the opportunity to capture that right-of-way that was never established 100 or 50 years ago. So that one property, that right-of-way was captured, we'll say. But this remainder has never been, I guess, subdivided in a time that we could get that right-of-way. So it shows no additional right-of-way. And that's why I say, just from what I observed from this 2008 plat that was done by Morris Talbot. Morris Talbot was a surveyor, that it appears that this is not county right-of-way. And then we've also recognized, all our documents indicate that we don't maintain that as a public right-of-way. So now what we're talking about is, is it right-of-way, is it not, is it dedicated to public use? It doesn't appear to be. We don't maintain it, even if it was right-of-way. So again, these are a lot of pieces to the puzzle, but ultimately the question is being asked is, can they have a fourth or fifth access?
Jim, on
Yes,
this
sir.
plat, does it show the rest of that being, I think I can read that, as private access easement?
No, so this arrow points to a utility easement. Well, I'm sorry, you're right, it does say, and private access easement. There you go.
Yeah.
Thank you.
That's what I'm here for.
Again, lots of pieces to this puzzle.
All right, so with that in mind, then the consideration before us is solidified in as much as we're talking about access off private easements, correct?
I'll give the disclaimer that I did not perform a full certified title search. This
Understood.
is what I was able to
Predicated.
locate in our files as the most concise,
true.
most up-to-date documentation of the recorded easements and right-of-way on this piece of property.
All right,
So clarification, the two driveways, the roundabout, would you consider that being on Liberty Lane or a private access?
The little roundabout, I think, is just a private driveway. It only appears to be serving one property.
Right.
It's these three spurs that are in discussion, and they all three appear to be dedicated to
Private
some easement.
easement.
Yeah,
Okay.
not right of way.
Mr. Chairman, I do have one question for the applicant.
okay.
And just for clarification, for him to come up. Yes. I just got to get a clarification. I know I probably know the answer, but I need you to put it on record. You indicated that you had sold or divided this property 3 times already, correct?
No, sir, one time.
One time? You made a statement that you had divided it 3 times, I thought.
I
Am
don't-
wrong? How many times have you sold property on this?
We bought 13 acres initially and sold the old house off with 3 acres one time,
That's
and then
when
we
got
built.
3 acres.
Yes, sir.
Okay.
And then now we're just asking
Asking for the one.
Yes, sir.
Okay, that's where I got confused. You said 3. I thought you were talking about 3 lots.
Oh.
Okay.
Thank you.
I think I'm finished. Thank you.
All right, good, Mr. Douglas. All right, who else? All right. Typical hearing protocol is for the applicant to provide any rebuttal to clarify anything that was just said in that exchange. Do you have anything to add at this moment?
Well, the only thing I have to add is I think there's a confusion. I might not be articulate, I'm not presenting it exactly right, but I think there's a confusion. And I don't know if you can go back to the records of when we asked for approval on the split initially, when the county attorney or the county person,
We're with you.
when she decided to end Liberty Lane. That was confusion to us. We never really understood why she ended Liberty Lane in front of the 13-acre property, but we didn't argue the point. So it might have hurt us by not arguing the point that Liberty Lane should have stayed going to the east and then stopping to the east of our property. Because it did get, when we first bought the property, the 13 acres, they maintained that. They plowed it in the winter and maintained the road until we decided to sell off the 3 acres and consolidate down to 10 acres and build another house. That was the only confusion that I could really say that.
All right. Anything else to add as a final statement?
Just that we would like to be approved just because of what we've presented today. And to have our daughter closer and just, I mean, we're not planning on building a subdivision. It's just one house, and just like to have it approved.
All right, thank you.
Thank you.
All right, Mr. Fisher.
Okay, so if you look at page 2 in your staff report into page 3, you do have motions to both approve and deny the waiver. You've heard evidence and testimony. You've heard from staff, even looking back at plats and determining whether or not where Liberty Lane goes, if this is a private access easement or not. It appears from that last plat that it looked like it was a private access easement. So either way, to make it cleaner, the need for the waiver of the number of parcels off the access easement is needed. So you've heard evidence and testimony of that. You've heard evidence from the applicant as to why she desires to move onto the family property, and that everything they proposed is compliant with what's in our existing regulations. On page 3, you do have potential conditions of approval. And that shall be, the waiver shall only apply to the plan reviewed at the July 22nd, 2025 Oldham County Planning Commission public hearing. A minor plat application and survey must be submitted to staff for review and approval prior to the issuance of any building permits. A shared road maintenance agreement shall be prepared and agreed upon by all parties affected and recorded with the minor plat. So that will be required. Just because you all approve, if you all do choose to do this, approve a waiver today, they would have to come into our office to get that approved. That would be sent out just like any other minor plat to agencies for their review. Make sure addressing is good, fire protection is good, all of that good stuff that takes place with that before any sort of approval would be required or allowed. They would have to get a shared maintenance access agreement. I don't know if one's in place yet, but they would have to get that between all the members of their family as well as that additional farm that takes access. We tell people that, and a lot of people say, well, it's just family. Well, one day it might not be family, and you want to make sure that's in place. So we make sure that that's done as well. And then Sandy did add in there, I believe, that they would need to go to the appropriate Board of Adjustments to get a road frontage variance because this isn't on a public road. So that acre tract of land would be required to have 150 feet of road frontage, so they would have to go and ask for the road frontage variance from the Board of Adjustments. It's usually easier to go before you all first to get approval for that waiver, because if you all don't approve the waiver, then that's an unneeded trip to the Board of Adjustments. So we usually ask them to come to you all first, get that approval, and then they would go before the Board of Adjustments if they're approved today to get the road frontage variance for that. So that would be the 4th condition of approval. I think that's it.
All right, thank you, Mr. Fisher. Mr. Baxter, anything?
No, Mr. Chairman.
All right, commissioners, questions, discussion? See a lot of furrowed brows. Floor is open for motion making.
I have a question or a comment or something here. I mean,
Sure.
I know what they want and I understand what they want, and I don't disagree with what they want. I don't know if we have a proper presentation for what they want. And we're getting down to where we are making waivers on very little justification, and that concerns me. You know, not that I don't understand their justification. It's just not that we've not had really just real justification. And That's just my comments.
Right, right. No argument there. Perhaps a perspective on this that may carry some weight as well is that there's no opposition, right? And a lot of times that does speak volumes, right? So, a couple of thoughts on this. Based on the second attempt to provide some rationale in support of the argument, probably adequate content there to make a decision on, is what I think. I recognize that it's not the slam dunk that you're used to normally seeing in an application space that an attorney's going to come to the podium and make. It's not quite at that level, but there's probably enough in there to decision on, and one way or another. So, floor is open. Go ahead.
I just want to add on to that. I mean, and I think you're justified in what you said, but, just keep in mind, you all do have the luxury at your all's cases before the Planning Commission, and most of the time you have legal counsel up here giving those arguments. In cases where legal counsel is not required, they obviously don't do this for a living and they come up to a podium and there's, 15 sets of eyes staring at you the whole time. It's a little nerve-wracking. It's even nerve-wracking for staff when we get up here. I remember my first time doing that. So, I think while maybe they haven't articulated as well as maybe legal counsel, would for them, I do think you've heard, the reason why they want to. They have talked about just down the road that obviously, parcels have been created there. And once again, there's still more steps to this puzzle as well. I mean, they have to get the road frontage variance from the appropriate Board of Adjustments. They still have to come to the staff for the minor plat approval that gets sent to agencies. So I'll just say that in kind of in their justification, because I've been on that end and seen all you all staring at me. I'm supposed to know what I talk about too, so.
Ms. Jones. Coming back to you, Ms. Kraus.
Is the floor still open for a motion?
Absolutely.
Or are we still discussing? Did you? Oh.
All right, let's catch that input first.
For me,
Okay.
the undue hardship has already happened with the confusion in the road, right? So to make a motion on undue hardship, I mean, they're not in wheelchairs. She isn't trying to take care of them immediately, right? But I understand the situation of the aging population and needing help at some point. But the undue hardship to me here is what's already happened. They thought they had a road. It got changed somehow during the process. So I think the motion has to be a little altered because of that. And I'm just asking, can we do that?
Sure.
Okay.
All right, so, and I'm going to defer to Mr. Baxter in terms of how far astray you may go, but I mean, it's still, the basic framework here says that you make a decision based on what is in the record and not from some other information or information that isn't on the record, okay? So that's the primary motivation, and then basically you're going to tag that back to the framework that we operate within. So, all right? So, Ms. Jones, you ready?
Yes.
You're up.
Docket PZ 25-018. I make a motion to approve the waiver for the 5th parcel on the access easement due to the fact that strict compliance with the regulations would create an undue hardship, given that the applicant would like to live near her parents as they age, and also due to the fact that there is no opposition to this case, and also given the confusion with how the road, when this parcel was purchased, it appeared that it was possibly on a road, so this wouldn't have been an issue if that had not been changed at some point. And also, I'd like to include the conditions of approval.
Thank you, Ms. Jones. Mr. Baxter?
Ms. Jones, I mean, just to articulate a little further, so when you look at the language of the statute that's put in here, it talks about a natural or man-made physical condition of the property, And I believe you're articulating that the roadway, their understanding of the roadway was that Liberty Lane went by this piece of property, and they have now been told that that is not the case. And are you considering that to be a man-made physical condition which has created this problem? That understanding, Mr. Chairman, I think you have an adequate motion.
Thank you, Mr. Baxter and Ms. Jones. All right, we have a motion on the floor. Do I have a second?
I'll second.
Ms. Davis, thank you. All right, discussion. Don't all rush forward. All right, we will move into a roll call vote. Ms. Edgar.
Mr. Marsh? Ms. Walzer?
Yes.
Ms. Nasser?
Yes.
Mr. Klingenfuss? Ms. Jones? Mr. Hampton? Mr. Finney?
Yes.
Ms. Kraus? Mr. Elder?
Yes.
Mr. Douglas?
Yes.
Ms. Davis?
Yes.
Thank you, Ms. Edgar. And the motion to approve PZ-25-018 has been approved on a vote of 11 to 0. All right. All right. Mr. Fisher, anything additional?
Mr. Chairman, if I can interject one thing.
Sure, please.
I anticipate, it's not, I haven't asked it to be put on the agenda, but I anticipate that next month we will need to have a closed session to discuss pending litigation. I've had some conversation with our legal counsel regarding the Sunanza case, and I think they may want to come and update you all about the status of that. And we also have we're having some discussions about how that moves forward with them in early August, and we'll probably want to talk with you all about that at that next meeting.
Thank you, Mr. Baxter. All right. Mr. Fisher, you got anything?
No, just we do have a hearing next month, so same time, same place.
All right. Anyone else?
Yes, Mr. Fisher.
Marsh, please.
SRC.
SRC, we're not going to have a quorum for SRC on Thursday. I have a conflict. I understand there's at least one more. We're not going to be able to hold that one. All right. Anyone else? Good to the cause? We will stand adjourned. Thank you, everyone.